Hello, my name is Jim Vitko, and I'm one of the CSLEA attorneys assigned to the legal staff in our Southern office. One of the more frequent legal issues we deal with at CSLEA involves what is known as AWOL, or absence without leave. As the name implies, AWOL means that you're not at work and you don't have permission to be away from your job. This can happen in a variety of ways, including unimproved sick leave, leaving work without permission, or simply being unable to report to work due to some other problem. For the purposes of our discussion today, I'm going to talk about unapproved short-term absences, as well as the AWOL statute itself. Short-term unapproved absence, or DOC, normally involves less than 5 consecutive days. Employees can expect that they'll not be paid for this time, even if they have leave balances available. Employers, at their discretion, can also take informal or formal disciplinary action under Government Code 19572J. If you're absent without approval or leave for a period of 5 or more consecutive days, your employer can invoke Government Code Section 19996. Should this occur, the employee is deemed to have been resigned from his position and is separated from state service. If this occurs, reinstatement can be granted only if the employee makes satisfactory explanation as to the cause of the absence and failure to obtain leave. The employee must also show they are ready, willing, and able to resume their duties, or have obtained the consent of the department for a leave of absence should they be reinstated. The employee has the burden of proof, and these appeals and reinstatement from AWOL is very rare. Both short-term absences and AWOL can have catastrophic effect on state employees. Consequently, it's important to understand how to avoid AWOL. First, it's important to understand that leave is not automatic. It needs to be approved by the employer. As a result, it's necessary to understand and follow your department's policy with regards to leave. Failure to do so can subject the employee to DOC or to AWOL. For example, let's look at this in a sick leave scenario. All of us have some time or another used sick leave. When this happens occasionally and for a limited duration, there's usually no problem. Contract Section 9.3 provides that sick leave may be granted for illnesses or injury, medically verified incapacity, medical or dental examination, or for sickness of certain family members. If there's some identifiable reason to suspect that the sick leave is inappropriate, the employer can and often does request that you provide a doctor's note to substantiate the illness. AWOL, or DOC, in these circumstances can arise in 2 different ways. First is when the employee fails to timely notify the employer that he'll be out sick that day. Failing to call in timely or follow policy can raise an AWOL issue. Secondly, when the employee is asked to provide a doctor's note and they fail to do so, which may deem the absence to be unapproved and raise the AWOL issue as well. The easy solution here is to make sure that you understand your department's policy on calling in sick and notify your employer appropriately. Do not avoid your supervisor and always follow the department's written policy. This is particularly important if you've been using sick leave on a frequent basis. Also, when you're required to provide substantiation, make sure you do so timely. If you don't feel there's an identifiable reason for your supervisor to ask for a doctor's note, ask why they're requiring it. If you don't feel the request for medical substantiation is appropriate, call CSLEA and our legal staff can assist. It's important, however, not to disregard your employer's request for a doctor's note or to be insubordinate. That can get you disciplined. The time docked, or it could result in AWOL. Another issue that can cause AWOL is long-term or chronic illness. Employers have the right to expect employees will come to work, and often there's frustration when an employee frequently is calling out sick. If circumstances arise necessitating long-term or frequent time off, we suggest that you contact your employer or HR to request FMLA. The Family and Medical Leave Act of 1993, commonly known as FMLA, is a federal law requiring employers to provide employees with job-protected and unpaid leave for qualified medical and family reasons. While this will not give you any additional paid benefit, it will keep your employer from taking action against you based on the protected leave. As with short-term sick leave, make sure that you understand your department's call-in policies, specifically when and who needs to be notified that you're taking sick time. With approved FMLA, the employer cannot continually request doctor's notes, but you still need to keep your supervisor informed as to the days you're going to be out on leave. Employees are also occasionally faced with industrial injuries. In some instances, this requires significant absence from the workplace. When this occurs, miscommunication can cause employers to attempt to dock an employee's time or invoke AWOL. The best way to ensure this does not occur is, again, to keep your employer informed you will be away from the office and to follow your sick leave policy. Finally, when dealing with non-sick leave absences, be sure vacation time or other leave time is approved. Keep copies of emails or other correspondence with your supervisor to avoid miscommunication relating to approved or unapproved absence requests. If you need to leave the workplace for any reason during work hours, be sure to inform your supervisor and get permission. As always, if you have any questions or need assistance from our legal staff, contact CSLEA and we're here for you.